Thank you for being here, everyone. My name is Pierre, and I am moderating today's webinar. Today's webinar is titled Strategies for the H-1B Fiscal Year 2025 Cap Season by Velie Global Law Firm. Today, we're joined by 30-year immigration attorney Jon Velie. Thanks for being with us. I'm not going to talk too much further. I'll give the mic over to you. Tell us a little bit about what's going on in the H-1B world. There's a lot of questions that come in every day from what I can see. Um, when it comes to the digital online filing and what's happening differently this year. So over to you.
Thanks, Pierre. We talked about this a little bit last week, so I'll hit some of those high points. Yes, if you want to jump in and as well, you're welcome to. Anybody else that wants to ask some questions, please do. We'll make this pretty informal. We're going to be here about a half an hour. So a couple things. There's a registration period again. What that means is there's a lottery again. They're going to be looking at the focus on the beneficiary and then informing the different petitioners who the beneficiary was picked up on to register. There's going to be online filing, which I think will really help in a lot of ways. Probably in costs of mailing, get you there. You can do it one more day, right? If you don't have to mail it the day before, we get one more day in that hectic deadline. How it works, if you don't know, is that the lottery last year was started on March 1st, open through March 24th. We don't know what those dates will be this year yet. They haven't said, but they had about 3 weeks to register. The petitioner can only register for the beneficiary once. If the petitioner registers for the beneficiary a second time, that's considered a double registration. Double registration has been a really interesting thing. There's been a lot of cases with RFEs, denials, and a lot of questions about what double registration is. Double registration, again, is if a company registers for a petitioner or for a beneficiary twice, and then if they do that, Yesh tells us it's March 6th to March 22nd. Thanks, Yesh. So we do know now. March 6th to March 22nd is the period of time to register. Companies can register on their own. Lawyers can register for companies. Don't do both. What I mean by that is don't have a lawyer register for you and register for yourself for the double registration issue. But if you need help with that, contact us. We'll tell you how to do that. Going back to double registrations, USCIS has expanded what double registrations are to include the commonalities. I think USCIS has stretched to a pretty long list of things that it thinks a double registration, including being in the same office with or same building as another company, having former employees, sharing some office staff. They've even extended it to companies who had relatives in other companies. I think that's probably prone for litigation. I think that's extended beyond what the law says, and definitely what the notice and comment period was when they passed that law a few years back. And really where I think it can even include is related companies, being companies owned by the same individuals if they have a reasonable purpose for hiring or wanting to register twice. That's what it says. So, but that litigation hasn't happened yet, and it's probably due. So moving on to, so you want to be careful about it. Right now, if you were to ask me whether to do it or not, I'd probably dissuade you from doing it for the hassle. But if you did it and you're getting RFEs or notices of intent to deny, we're glad to take a look at those and help you defend yourselves in what may not be against the law or fraudulent, even if immigration is saying it is. There's a number of cases on that, and we're glad to discuss that with you. So that's kind of the stuff, what's coming out. Let's talk a little bit about strategies. We have strategies for companies. We have strategies for individuals. In this call, there's probably a lot of folks that are involved in the staffing business model. The staffing business model is where staffing companies, those are folks that hire, train individuals to work for them on projects. And those projects many times can be at a third party, meaning another company's location, at their location, at a remote location, at a split hybrid remote own location issue. And all of that has raised a number of issues and some litigation. Very famous case called IT Serve Alliance that broke in 2020 that really curtailed the way USCIS was coming down on the staffing model for H-1Bs, and it really paled it back. So what did IT Serve say, and what did it get those filing for H-1Bs today? Well, it meant that you did not have to prove with an itinerary and third-party contracts, which also means third-party letters, what the beneficiary was going to be doing for the full 3 years. It even allowed, and it looked at other federal laws that could allow some time where the beneficiary was not even working at all, right? As long as they're being paid. But that was where you pulled in, sick leave and some other cases, ERISA cases that allowed time off. So what USCIS was doing was, you had to say what the beneficiary was going to be doing for the full 3 years. And if it wasn't long enough, they'd cut them short. They'd even cutting them so short that you get an approval with the expiration date in the past, right? So IT Serve got rid of that. So what happened? A couple of things. One was you could get visas approved. The Biden administration approved cases at about a 93% approval clip, the highest ever. Obama was at 88, Trump was at 60. So a big jump in approvals, but a big increase in site investigations. So that site investigations were the way to find out if they thought there was fraud going on. And a lot of these are happening right now. So companies that were filing cases that had some issues or didn't have issues, investigators could come by and ask what's going on, talk to the beneficiary. If the beneficiary had a home address, might show up the beneficiary's house. Beneficiary might not be there. They might be at work. So they're talking to their spouse, their kids, all sorts of things. Very scary. There's some good rules of thumb. It's a volunteer scenario right now. There is some proposed legislation to make that mandatory, but it's volunteer. Advice we give is don't talk to the adjudicating officers. Hire an attorney to do that for you. And that's completely legal. And that's the way it is. Any major decision in your life, you should probably have an attorney helping you with it. On whether or not an investigation into your company or into your job is there. Get counsel. Give an attorney a call. Most of us will talk to you about it immediately and jump in to help. And that's a good way to handle site investigations. Another thing that happened after that was the consulates, even though the IT Serve case was very clear on its face that you couldn't ask for all these things, consulates started asking for 221Gs. What a 221G is when a consulate appointment says we're going to take this case under advisement. Right now, it's technically a denial, but what it really is they're kicking it up to somebody or taking some time to look at it. Many times they're asking more questions, and many times they're asking for the things that USCIS is not able to ask for: third-party letters, contracts, and so on and so forth. Right. So these are difficult situations. There's no one size fits all on how you handle it. You don't have to answer any of the questions. You can answer some of the questions. You can answer part of the questions. You can even answer questions that aren't being asked to reframe the questions. That's pretty nuanced stuff. So my suggestion is use an attorney if there's any of that going on, whether 221G or whether there's a site investigation. All right, well, that's kind of that. So what are some other strategies in obtaining visas? Well, what is the size of the company? Right. So what's too small? Well, there are some black and white too smalls. I would never file an H-1B for a company that didn't have any employees. There are 3 questions that will trigger request for evidence when filing an H-1B around a company. One is going to be, when was the company established? The next one is how many employees does the company have? And then another one is they'll have both revenues and profits, right? Profits aren't as important as revenues. Lots of companies are not profitable. Lots of companies are R&D companies, and they gush money, and they still work. And new companies probably not as big of a deal. If you're funded, if you have a line of credit, if it's a spinoff, There's all sorts of ways you can explain that. And I think if you have any of those questions, there's nothing against the law to inform USCIS and provide evidence that you are going to be a viable or are a viable company, right? So for example, we have these big contracts, right? Of course, we're going to make money even though we just started. Another thing is we've been funded. And not all of these are staffing company situations, but there's all sorts of companies that are open for business, might just be new and funded, and they can still get H-1Bs. Number of employees, I think, is critical. I think, of course, zero is I wouldn't do that because you wouldn't put there's a zero thing. Let's get to that answer later, Pierre. But, you know, I think 5 is safe, right? 5 employees is there. We've seen some companies where they say they're 0 and even the owner of the company is not an employee. That's going to pretty much trigger an RFE and a site investigation. So my suggestion to new companies is invest in your company, hire some people, you know, get them working. And then location's really interesting, right? So here we are coming out of COVID. A lot of people haven't come back to work yet in their locations or hybrid, things like that. And is the space too small? You know, is there enough space for the number of employees that you are trying to bring in? Not just the one you have, but USCIS. We've seen it in RFEs and notices of intent to deny, where a company has applied for a lot of H-1Bs. And then they'll even go back years and say, where are all of these people? Well, there's factual reasons that they may not still be there. They may have moved on, those sort of things. People move. These hybrid things are, you know, immigration doesn't seem to like them, but there's nothing illegal about it. We see some employers have actually residential housing for their employees, right? And allowing them to work from home. Now, the minute you say that they're working from home, expect USCIS to knock on their door. Nobody likes that. But where does this come in? So there's 2 places. One's the LCA. What's the location they're going to work? Is there another place they're going to work? So if they're going to work at a third party, while the IT serve case says you don't have to put in those agreements, the LCA still has the location. So if they're going to be placed at a third party location on the LCA, you got to name that that company and the contact people and where they're going to work, right? So they're sort of still asking questions. And we're seeing some, with new legislation coming out, even by this administration, they're not done wanting to know about this stuff by any stretch of the imagination. So it's really interesting to do strategic calls on what you're going to do, how you're going to do it, and make it work. So one of the things that was left after IT serve is the concept is, does the work exist at the time of filing? That's what the memo says. That's the law that they're pulling out of the case. USCIS has flipped it a little bit. They call it, is there a bona fide job offer, right? If there's really a real job here is really what that means, right? And so that's what they're looking at. I think there's some ways to approach that. One is if you have a history of your company of making money, meaning you're not brand new, and you can show, look, we made $5 million last year. We had, 15 contracts. We currently have 10 more contracts. We expect to have even more contracts. Our specialty occupation employer, our software developer, might work on these projects, might work on other projects. That should get you an approved H-1B. Now, the question is that going to get you an approved through the consulate? It should. The consulates sometimes want more. Ways to come back to that is with, real MSAs, real projects that you have, especially if those projects allow your business model to add more people when you want. So multiple projects, things like that. There's some thoughts around that we can say at the end of the day, the real question is it real? Can you make a legitimate argument indicating the reality of your company, right? So I think the way to say, does the work exist at the time of filing, or is it a bona fide job, is, look, we're a successful company. We're making this amount of money, and we have this many employees, and we need to expand our business. And this is our business model. And that should get you there. I think that would get you past any judge. If USCIS was coming down a little too hard. I don't suggest you do it for litigation, but we're seeing a lot of success in those sorts of arguments, and that's a good way to position yourself to show that you're a legitimate company doing legitimate business and bringing in more people. So those are some strategies right now. How are we doing on time, Pierre?
We're doing good, John. Let's get into a really important thing and then a question. Question doesn't mean we're ending our session. It just,
No,
I
no.
think it could be a good
Yeah, well,
motivation.
it could spur the. I guess we got about 10 minutes, so
Okay.
why don't we open it up?
Yeah. Yeah. So the biggest news that we've been seeing, of course, and what Business Insider recently wrote about is the excitement of having now the pick go to the individuals rather than the submissions, right? That's the really big news here is that you can be an individual that has one company or 10 employers or 20, but it doesn't matter because now the pick is going to be based on that individual. And therefore, it kind of, makes it that you don't have to get multiple registrations because they're not going to increase your chances. That's what we saw online. But the question that came in is are there any changes for the H-1B cap exempt employers?
I want to kick this over to Yesh, and then I'll follow her up. Attorney Yesh, you have any insight on changes to cap exempt employers?
Um, from what I'm seeing, there isn't any changes or any modifications that they're doing since they don't have to go through the registration process. We bypass all of that.
Right.
Requirements have not changed for what is a cap exempt employer. So far, the only changes that we're seeing take effect or will take effect soon is for cap cases. So yeah, there's nothing that needs to be updated for cap exempt.
Yeah, it's interesting. The cap exempt, what is it? Maybe we should talk about that for a second. So the cap is a numeric limit, that's what the cap is, of how many H-1Bs are issued in a fiscal year. Fiscal year starts October 1st. The earliest you can file a visa prior to a start date is 6 months. That's why April 1st has always been the date you file H-1Bs. And and up until about 3 years ago, when there was a lottery, you'd have to file the entire visa petition with filing fees, pay your attorneys, all that kind of stuff, and then you might not get picked up, and they just send it back to you. They then changed it the last 3 years to have a registration first, so that happens in the month preceding the 6 months, which is March, and as Yesh pointed out, it's March 6th through 22nd this year. And so it's a $10 fee to register, and so we didn't see that go up. We do think there's some increase in filing fees, although not as significant as they were going to be. And there was some positioning to change some law, though I haven't seen that new law go into effect yet, luckily. So that's kind of that. So cap exempts are people that don't have to file for that. So there's a couple of examples. One are institutions of higher education. Those are universities. Others are nonprofits affiliated with institutions of higher education or research, right? That's what they have to do. And it has to be primarily research. We've looked at that. You can't just have some researching. Research has to be the primary purpose of it to work. We've seen some litigation on that. And it's pretty hard. I mean, it's a pretty limited thing. And we've seen and then there are schools affiliated with like high schools affiliated with institutions of higher education. You can't just say, most of our students go to the local college, right? There really has to be an ownership, if it's a private school, of the same owners, or a public school, the same regents oversee it, right? So sometimes some charter schools will fit into that category. And then interestingly, we've seen some business models around companies that have the ability to hire people under their cap exempt status and subcontract them back out. They charge a fortune. I've never done one, but I have, had conversations with people that have those companies that do that. I don't know anybody that's used it. Again, they were charging a fortune to do that, and I think at that point it just wasn't worth it for whatever risk was involved to structure it that way. So I'm not condoning that by any means, just saying that I've seen some folks try to use the cap exempt structure around getting people in that didn't make the cap. Pierre, any more questions?
Very good, John. Yeah, we have one more question, and I'll try to rephrase it. So the question is, how would a beneficiary know the information of being selected or picked up in a lottery when they have multiple companies filing for them. Is the only way to know through your employer, or is there a way you could know on your own? Thank you.
Yes is very knowledgeable on that. Yes, you want to take us through how, and that's a little different this year, right? Yes, you with us? We can't hear you if you're talking.
Maybe she's having audio issues.
Might be. So my reading of the new proposal is that they're going to have how they're going to inform you is it's going to go through the beneficiary and list all the different companies that they registered under, right? That's so as the beneficiary, you're going to know. The company's not going to have to tell you. You'll know. Yes, did I get that right?
Sorry, can you hear me now?
Yeah, now we can hear you.
I apologize. I've been having a little bit of
to
technical issues.
regurgitate what you told me about how they're going to inform the recipients of that.
So it'll be, we don't have like the exact details. You will get a notification, just a registration selection notification. And it'll be you as well as all of the employers that have registered for you. So it's not just one single person. Like if you get picked up, it's not just one company that'll get notified. Everybody that's registered with your passport or your unique ID will get notified that your registration has been selected.
I think that adequately answers it. So you'll get to know. You don't have to wait for the employer to tell you.
Yeah. Usually, I think last year it was, the registrations were done through the employer. So the employer would get a notification on their account and they would then inform them, the beneficiaries. Sometimes there would be a delay. Sometimes multiple employers would come in and say, oh, we got picked. And it was kind of a mess last year. But I feel like this is a little bit more refined where everyone's just getting notified immediately and it's a unique ID.
Great. Thanks, Jess. Got any more?
Very helpful. No more questions that are coming in right now at the moment, John, but I would like to ask a personal question that I've seen being asked offline. And that is, when you look at all the different new rules that are coming in, would you say overall that it's positive or negative? Because we hear a lot of great news right now on the internet. Is that true? Is it actually positive? Is it better? Is it more fair this year? Or would you say, yeah, it's the same, just rephrased differently?
I probably. I think this administration, for the most part, is pro-immigration, right? So they want people to be able to get the visas. They give a high number of them. They are on the lookout for fraud, and because of that, they're looking for people that are doing it the wrong way. Nothing wrong with that. So I think for the most part, it's going well and progressing. That hasn't always been that way. We've had where this business model, the H-1B as a visa, I think if we did not have a change in president last time, might not exist anywhere near what it is today. Which is really, it's a very important visa for us. It is the visa for college graduates. Right? If you have a college degree, this is the visa you get. I think the problem with it is that there's this arbitrary number by Congress that there's only 65,000 available with an extra 20,000 for graduates of U.S. advanced degree holders, right? So meaning masters and PhDs. And we need everybody. I mean, we have a very, very low unemployment rate. We have a screaming white hot tech industry, which is gobbling up about 70% of the H-1Bs. 70% of them, give or take, are Indian. So that's not enough visas for everybody, right? That means every doctor, lawyer, white collar employee, teacher are, they're all after a tiny, tiny little piece of an opportunity to work, and we can tell it's not enough because the lottery numbers, 800,000 people applied for these 85,000. I appreciate they're trying to change the registration. I mean, the smart move would have just been getting rid of the caps and letting the market bear. Then you wouldn't have double registrations, and people would be able to graduate college in the United States and start working for the employer that wants them when they want them. I mean, right now, that means registering is 7 months prior to when the start date of the visa is, right? I mean, it's just like we created a problem. So that's my 2 cents on it, but that isn't going to change. Definitely not going to change in a political year, especially when, once again, immigration is a hot button topic, and people seem to merge all immigration together, even though they're about as different as they can be. But we're seeing the registration. Hopefully that will resolve some of it. I don't know if that's the perfect answer, but it is what it is, and we'll deal with it.
Very good. Thank you so much, John, and thank you everyone for joining us today. Just a quick reminder, Attorney Velie and Attorney Yesh are both attorneys, but that doesn't mean they're your attorney. So everything that we discussed in today's webinar, please do not take it as legal advice, and you're more than welcome to visit velielaw.com or onlinevisas.com for H-1B inquiries. In fact, if you're interested in having a strategy session with Attorney John, you could email Jon, Jon, at velielaw.com. Velie is Velie, and you'll be able to speak to him. And any closing remarks that I missed, John?
Oh, it's great, Pierre. I would like to kind of throw that out there, right? That we offer strategy sessions to companies that want to know what to do going into the season. We have strategy sessions for individuals. Some of those are paid, but we're glad to do it, and both Yesh and I can talk to you about what's going on. If you do have a 221G or a site investigation or something very significant and time sensitive, call us up, and our number is 405-310-4333, and talk to any whether it's Gabby or Christy or Jara, and try to get us on your schedule as soon as possible if you have any of these big quick things. But we'd love to talk to you about the strategy going in. We'd love to talk to you about what your plans are for immigration, and help you look at that in a holistic way. But we can also talk about individual visas. We do that every day. We're meeting just like this. We'll open up our visas.ai technology, and we'll do a strategy session where you can then take that away with you. You'll have your own secure portal. You'll be able to see it, add things to it, correspond with our team, and it's an ideal way. We've really been able to do a lot of visas, and with I think we're a 99% approval rating from last year's cap season, and do them quick and have a lot of quality control. So we'd love to show that to you as well.